Good morning. Thanks everyone for joining us today. My name is Jaimie Cavanaugh. I'm legal policy counsel at the Pacific Legal Foundation, and PLF has worked closely with the Pioneer Institute on the issues that we're going to be talking about today. So for those of you who aren't familiar with Pacific Legal Foundation, we're a national public interest nonprofit law firm. We're dedicated to protecting constitutional rights, and one of our main practice areas is protecting private property rights. So although PLF is primarily a litigation firm, we also have a communications and media department, a strategic research department, a constitutional scholarship department, and then the legal policy department that I'm part of. So on my team, we work with legislators to extend and entrench our victories from court. So the director of my department is always saying that litigators can win a Supreme Court victory, but then when everyone wakes up the next day, nothing's actually changed in the law. So we still have to go out and work with state legislators to repeal or reform the laws when the court rules something unconstitutional. So today we're talking about ending home equity theft, and you'll get to hear a lot of the specifics from the panel that follows me, but I just wanted to give a brief intro to the topic. So PLF has been working hard on this issue for many years now. It's an issue that preys on, often the elderly or people who have paid their houses off and have all of their money tied up in a house, which is true for most people. Most people who own a house, that's their biggest asset. But at its core, home equity theft occurs when local governments take and sell property to recover a tax debt. So if I fall behind on my taxes by $10,000, at some point, the government is entitled to foreclose on my property and sell it or auction it, depending on the state you're in, to recover the $10,000 that it's owed. But let's say my property sells for $50,000. There was an outstanding question for a long time about what happened to that remaining $40,000. In most places around the country, the government could have kept and did keep that $40,000. But last year, when the Supreme Court decided the Tyler case, Tyler versus Hennepin County, the Supreme Court ruled that the Fifth Amendment prohibits the government from taking more than what it is owed. So this was a huge landmark ruling. And after securing that victory, PLF has been working hard, like I mentioned, with state legislators all around the country to get their laws in conformance with the Tyler decision. So we've been generally successful. We're happy to report that as of now, Illinois and DC are the only places that haven't adopted reforms yet to allow property owners to recover their surplus equity. Most of the rest of the country is at least attempting to comply with Tyler. And you'll hear, I think, about the Massachusetts reforms in a little bit. But PLF's work on the topic is not over. We're continuing to litigate many cases relating to different issues stemming from this. One of the major problems we're looking at is called what we call shadow equity theft, where the government says, sure, there's a procedure for recovering surplus equity, but they make it so difficult or the window's so short that it is basically impossible for a property owner to recover their surplus equity. Another issue we're looking at is just whether Tyler applies retroactively to people's property that's already been taken, and other issues about whether private parties who buy tax liens and then recover the tax debt, whether they're actually state actors for the purposes of the Tyler ruling or not. And I want to mention that we're looking at the shadow equity theft issue in Alabama, Arizona, Michigan, New Jersey, and New York. So anyone watching who has issues in those states, we'd be happy to talk to you about that. So the last thing that I want to mention is just that PLF maintains a website with information and updates on every single state. We're trying to add information about ongoing lawsuits. That's not on there right now, but the state of the law in every state is on this website. So you can visit that. It's homeequitytheft.org and take a look if you're interested in comparing states. So with that, I want to turn it over to Judge Bailey and the rest of our panelists, and I hope you enjoy the webinar today.
Whoops, there we go. Thank you. Thank you, Jaimie. I think I can be heard. Looks like it. So good. Okay, thank you all. Uh, so I would like to thank Pacific Legal for their leadership on this very important issue. Uh, we have been working at Pioneer Law Center, with Pacific Legal uh, since the Tyler case. And in fact, we filed a brief in that case. You'll hear more about that later on in the podcast. Pioneer Law Center is also a nonprofit public interest law firm. We don't charge legal fees. We're an impact litigation group based in Boston. We cover New England, and in particular, we also participate nationally on issues before the U.S. Supreme Court and have filed a number of amicus briefs in that court. So I would like to introduce my friends and colleagues who have graciously agreed to appear with us today. I'll do that very quickly. Charlie Liu will speak first. I'll do it in the order of their speaking today. Charlie is at the national law firm of, I guess, international law firm, they all say these days, right? Greenberg Traurig. And he focuses his practices on insolvency and restructuring. That'll become clear why he was involved in a few minutes. Uh, Go to their website and you'll learn a lot more about Charlie. It's a very impressive background. I can't go into all of it, but I'll mention a couple of things. That he is a Canadian and initially went to the University of Toronto. Um, Another one of those immigrants, never mind. And he went to law school at Hofstra, and then clerked for my good friend, Judge Alan Trust, in the Eastern District of New York. He's admitted in Massachusetts and as well as in New York and the Third Circuit and a number of other locations. You'll then hear from Andrew Gallo, who is both a trial lawyer and a bankruptcy attorney. I know him well, not only as a colleague since I retired, but also as a trial lawyer and bankruptcy lawyer. He appeared in my court, and I can vouch for his skills as a trial lawyer. He is at the international law firm, I guess I'll say, of Morgan Lewis, and has he is self-taught by attending the University of Pennsylvania Law School. Um, and he also clerked in the U.S. District Court for the Southern District of New York for District Judge Stein. And finally, Todd Kaplan, again, a lawyer that appeared before me with great regularity, and was an important presence in our court here in District of Massachusetts. He's a senior attorney in the consumer rights unit at the Greater Boston Legal Services. And again, go on to their website and you'll learn a lot of very positive things about Todd and his impact. He just never stops. So, and we're continuing to work with Todd. So with that, I'm going to turn it over to Charlie, who is going to get us started on home equity theft generally, at the Tyler case, and some of our work. So, Charlie, thank you.
Thank you, Judge. Hope everyone can hear me all right. Really grateful for the opportunity to be working on these matters for the last, let's say, over 2 years ago now. That was the summer of 2022 when we filed the brief in the Supreme Court case of Tyler versus Hennepin. And it's been an amazing experience working with Judge Bailey, Andrew Gallo, and Todd Kaplan on this really important matter. So a little take you guys back a little bit more on what exactly home equity theft is all about, legally speaking and procedurally. Like Jaimie said at the beginning, it's a mechanism by which municipalities have the authority to acquire a private homeowner's home deed on the house for a fraction of its value on the basis of back taxes, regardless of the amount of the taxes owed. Procedurally speaking, you first have to, the homeowner has to owe some tax, whether it's a mistake, it's a late payment, or basically any reason by which a homeowner may have owed property tax. That's step one. Step two, the county or the municipality that is owed the tax may issue a tax deed, right, on account of the tax. That tax deed becomes a renders the old taxes into a secured interest in the house, right? So now the tax, instead of being unsecured, is a secured debt owed by the homeowner. Now, what the county can do with that tax deed is to either sell it or keep it, one of two ways. Next step is to take the tax deed and then foreclose on the home. So that typically happens at the local land court, if there's any, or a lower trial court. Once you have the tax deed foreclosure, the homeowner often gets some time to redeem the foreclosed tax deed. In Massachusetts, it's 1 year, may vary for other jurisdictions. And upon the expiration of the redemption period, the title passes from the homeowner to the holder of the tax deed. So procedurally, that's pretty much what happens in most states, and we understand that was the case in both Minnesota and as well as Massachusetts. And talking about Minnesota, that was the state in which Tyler versus Hennepin revolved around. In that case, it was a homeowner who had lost her home over a $15,000 debt, and the house was worth at least $40,000 at the time of the taking. And in Supreme Court, what happened was the court ultimately held that the taking, right, the taking of the home was a classic taking in violation of the Fifth Amendment. What we did in that case, and it was me and several other lawyers at Morgan Lewis and Julie Frost Davies, we had filed an amicus brief arguing from the commercial perspective, right, why the taking was unfair and inequitable, on the basis that under the bankruptcy code and as well as state law, fraudulent conveyances are, a transfer of asset may be avoidable if it's not, if the exchange was not commercially reasonable, mainly that if there wasn't reasonable equivalent value for the exchange, then that transfer is subject to avoidance and recovery. Number two, that the disposition of that collateral, meaning the tax deed, was not done in a commercial reasonable manner. A lot of times with these tax deeds, when they were sold to investors and whatnot, there's not an open auction, or the auction process was flawed, where only certain people got notice of the auction. And finally, that the distribution of recovery was inequitable, meaning that the debt holder, right, the holder of the tax deed got, in addition to the tax debt owed, but the full value of the house, including whatever equity that the homeowner had in the property in excess of the debt. So that was the angle that we had presented to the court, and thankfully the court adopted some. I think Judge Bailey was there in person to adopt some of our arguments in the hearing, in the oral arguments portion. So that was Tyler versus Hennepin. Soon after Tyler versus Hennepin, but before the Supreme Court holding was issued, we found a client, Ms. Rodriguez, in Worcester, Massachusetts. That was a more hands-on experience for our team. Ms. Rodriguez was an elder woman who had retired due to health reasons and became behind on her taxes on a home that she owned outright. There was no mortgage, there were no encumbrances, and this is fairly typical home equity theft to happen to people like Ms. Rodriguez, who are either in the demographic of not knowing what to do with legal notices, not really have suffer from health issues, or are living in senior homes, not away from their house, the house that they own. But for Ms. Rodriguez, she too had no notice of what had happened in terms of her tax arrears. She one day someone knocked on her door and told her that, hey, your house, we own your house, we have your deed, it's time to move. So we helped Ms. Rodriguez file a Chapter 13 bankruptcy, where the primary goal was to, one, as I had mentioned briefly, to assert a fraudulent conveyance action against the deed holder, who was a private investor at the time, as well as a declaratory judgment action, seeking to get a judgment holding that the Massachusetts tax equity theft statutes are unconstitutional. After a fair amount of legal motion practice, we were able to settle the matter. But
Charlie, if I could, I'd like to ask for two. I have two very quick questions to make sure everyone understands what was going on in that case and in these cases generally. So you say that Ms. Rodriguez, she was not dealing with the city of Worcester at that point, right? She was dealing with the tax lien buyer.
correct. So in that case, the city of Worcester could have held on to a tax deed, but it had actually sold the tax deed to a private investor, who then was assigned the right of the city of Worcester and went ahead and foreclosed on the deed.
And if that private lien buyer, so she owed about $2,600. They bought it for about $3,700. Her property was worth $300,000 or $250,000, something like that. Would they have actually been able to keep all that equity?
They would have.
Yeah,
They would have, right, on account of the $3,500 that they bought the tax deed for. They would have, upon the expiration of the redemption period, they would have gotten full title of that house, which we believe at the time was worth at least $250,000.
And my last question is, well, Tyler had come down. I mean, the U.S. Supreme Court had said, hey, this is a Fifth Amendment violation, this statutory scheme, and that was Minnesota. But so you were trying to get this rule of law applied in Massachusetts to the Massachusetts statute. Is that right?
That's correct. At the time that we filed the avoidance actions and the constitutional action in Rodriguez, the Supreme Court holding hadn't come down yet. So it was only after that he came down that we felt that we had a really good argument. But at the same time, the defendants had arguments where they thought, or they had argued that the statutes were different, that the Massachusetts tax foreclosure scheme was different from that of Minnesota's, and we had argued against that.
Thanks.
So that sums up what we've been doing in Tyler and Rodriguez. I don't know if there's anything, if there are any questions at the end of this seminar or a panel. I'm happy to answer any questions.
Great, thank you. So thank you, Charlie, for that discussion of home equity theft, the Tyler case, and the Ramirez case, which was a creative way. It was really necessary, wasn't it, to try to claw back the funds that or the title to her in order. It was really the only way to process a case when it got to that point, pre-Tyler in particular. So thank you, Charlie. And there will be a chance at the end for people to ask questions. And now I'd like to turn this over to Andrew Gallo. And Andrew is going to follow up on Ramirez and is going to talk about another case in Massachusetts that did get to the end result without a settlement. Andrew.
Yeah, thank you, Judge. Can everyone hear me?
Yes.
Excellent, great. And thank you for having us here today to talk about this. Happy to do it. So just reflecting on what happened in Ramirez, it really was a remarkable result, and it was the creative strategy that was thought up by Todd and Judge Bailey and Charlie and the rest on the team. If you think about it, in that case, the municipality had received a judgment of foreclosure. I mean, the land court case was over, and we filed bankruptcy after the judgment, and were able to create enough traction in the bankruptcy through the challenge to the constitutionality and through the fraudulent transfer action in order to get bring the defendant in that case to the table and to get them to settle that one. And it was a remarkable result for the client. However, we didn't get the ruling that we wanted from the court, which was this statute is unconstitutional. And so to take everyone back to the fall of 2023, we were all sitting on a Zoom very much like this one saying, well, what can we do? We had a great result for Nancy, but we don't have the statute, we don't have the ruling that the statute is unconstitutional. And really, and I know that Todd and Judge Bailey will talk about the strategy, the broad strategy, but there was a three-pronged strategy at that point in time that we implemented. The first was to go to the legislature, lobby the legislature, try to make sure they understand this decision, they understand this law, and they understand what's going on here. The second was, let's take it to the press. Let's take Nancy's case to the press. Let's make sure the press knows that the Supreme Court has done this, that Massachusetts has one of the worst statutes on the books for this practice in the country, and this has to stop. And the third was, what else can we do in the courts? And that's where the Mills case comes in. And I won't take credit for this. This was, some combination of Judge Bailey and Todd, their brainchild. But the idea was, we need to take a case directly to the Supreme Judicial Court, and we need to file. And so what we did is we filed a declaratory judgment action, and we used the statute that says that the SJC has concurrent jurisdiction over equity cases, along with the Superior Court, to file the case directly in the SJC. And this was the case of Ashley Mills. Ashley Mills was a 26-year-old disabled single mother living in Springfield, Massachusetts. Her original tax debt was $2,000, her delinquent tax debt. Now it had grown. There had been some additional years where she had paid taxes and she hadn't paid taxes. And of course, 16% interest, which was in the old statute, was running on this. So the debt had ballooned to $22,000. However, she owned a home that we thought that was fair market value was worth over $200,000. And she had inherited this home from her grandfather, and she lived there with her 2-year-old son and with her also disabled mother. And she had gone through the whole process in the land court with the city of Springfield. And where her case was it was in a different posture than Ms. Rodriguez's case. The Springfield had gone through the process. They had the land court. The land court had set the right of redemption right. She had missed the redemption. And so they had filed a judgment for foreclosure, but the judgment had not entered. So technically the land court case was still alive. So we filed the declaratory judgment action in the SJC. This is in the wake of Tyler v. Hennepin, seeking a declaratory judgment saying there's imminent harm to Ashley because her house is about to be foreclosed upon, and in a procedure that is unconstitutional. Chapter 60 is unconstitutional based on Tyler v. Hennepin. So the SJC, we were hopeful that the SJC would take up the case directly. They didn't, but fortunate for us, they kicked it to Judge Callan in the Superior Court in Springfield. And they kicked it to Judge Callan to decide it on the merits. And so what the procedure that then ended up happening is we ended up agreeing with the city of Springfield on all of the facts in the case, stipulating to the relevant facts, because there were no facts in dispute. We didn't dispute that she had a delinquent tax debt. They didn't dispute that they had brought the case in land court and that they were on the precipice of foreclosing on her home. But Springfield also didn't dispute that, interestingly enough, that what Chapter 60 did was a taking. They didn't really dispute the Tyler v. Hennepin decision. They really attacked and opposed the relief that we were seeking on two bases. The first is that they said, well, you've got a land court case. You should have brought this claim in the land court. It was either it was a compulsory counterclaim, or the land court case was the first filed case. And you know, this was improper. You had to litigate it there. The second thing that they said is well, even though this may be a taking, there's a remedy in Massachusetts law, and they pointed to section 79, chapter 79, which is the general takings clause, which applies when, you know, the government takes your home to build something. And it provides you with just compensation. And they said, yeah, this might be a taking, but the law provides for this, because the law, you know, chapter 79 says when the government takes your property, you get just compensation. So never mind that chapter 60 says we can keep the equity. There's this other law that fixes it. And so we filed summary judgment in that case, and we litigated with Springfield over this. And we were concerned about Judge Callan sending the case to the land court. The primary reason was we didn't think it would be a great forum for us and for the client, which was borne out when during the Mills case, the land court came down with the decision in the Recco case, in which the land court upheld chapter 60 in the wake of Tyler for various reasons which we disagreed with. But the other reason was we felt if the case got sent to land court, we might not get the decision that we wanted, which was a declaration that this was unconstitutional, which is what we thought was necessary to get the legislature to move on this. But Judge Callan wasn't having any of that. He said, the SJC sent this case to me. Obviously, they want me to decide this, and I'm going to decide it. So if this is properly here, you know, this declaratory judgment action seeking unconstitutionality is, while it's related to the land court action, it raises different issues than what's raised in the land court, which is simply redemption rights and the amount of redemption, et cetera. And I'm going to decide this. And decide it, he did. He gave us a great judgment on summary judgment, declaring that, well, I should say, not before Springfield made a last-ditch effort, relying on the Recco decision to make the same arguments that were made in Recco in the Mills case, to say that, well, this is not really unconstitutional. Judge Callan rejected those arguments and basically held, on the same basis that the Tyler case was decided, that Chapter 60 was unconstitutional. It was an unconstitutional taking for the same reasons, because it did not afford the homeowner the opportunity to redeem their equity after the foreclosure took place. But not only did he find it unconstitutional, but I'm just going to read the last sentence of Judge Callan's decision, in which he said, and I quote, "The statutory scheme," referring to Chapter 60, is in its present form is untenable and requires legislative correction. So it was really the decision was not only declaring it unconstitutional, but it was a call to the legislature saying, you need to fix this. And I think that, combined with the other avenues that we had pursued, finally put the pressure on the legislature to do something. And so for that portion of the story, I'm going to return it to Judge Bailey, and he and Todd are going to talk about what happened in the legislature.
Thanks, Andrew. That was a ruling by a state superior court judge, and I'll note the importance of this point. It was not appealed, right? So we were ready to go if this had been reported back to the SJC, or if it had been simply appealed in the ordinary course to the appeals court, the middle level appeals court in Massachusetts, or gone to the SJC, which is what we were hoping for. But the reality, because we're still confident that we would have won there. But it was the Mills case that seemed to be enough to ignite the legislature for reasons that Todd's going to talk about now. I want to mention to attendees that if you have any questions, please put them in the chat, and we will deal with questions at the end of the webinar. So let me turn then to Todd Kaplan, who is going to talk about this multifaceted strategy that this team had employed that involved both responding to media requests and to litigating in other forums, and doing something that I had really never done before, gone to the state legislature to explain how this should work. And I want to mention the RECO case. There were I don't know, unprecedented number of amicus briefs filed in that case, including by PLF, including by this group, but also the Real Estate Bar Association on our side, or on Ms. Recco's side. There were a couple of briefs that were filed by other communities and by the Mass Municipal Association, somehow still arguing, that Tyler didn't apply for some reason to Chapter 60, which still strikes me as sort of ludicrous. But Todd, let me lateral to you now.
Well, excuse me. Thank you so much for the opportunity to speak today, and want to thank you all for attending. I just want to say a little bit about Greater Boston Legal Services. We've been a civil legal aid organization for over 100 years, and we work statewide and actually nationally on many, many issues. And I think that let's step back and think, and I want to thank Charlie for bringing this up, like, who are these people? These are very vulnerable homeowners, often what we call cash poor and house rich, okay? They have successfully paid off their mortgage, which is rare, or they inherit their property like our client in Springfield. And they are struggling to pay taxes. They want to pay their taxes. They want to do their fair share of supporting our government in its essential functions, but they are struggling, and they often fall behind. And this is the other piece of this, and we've kind of touched on this, but I want to really highlight it, is that in Massachusetts, there was a very active debt buyer industry that was buying these tax titles. And as you can imagine, our interest rate is 16%, and they were really not willing to work with people to help them get current. So they went to the municipalities. They were selling it as a solution for the municipality. We'll buy the tax title for even a premium over the taxes owed, and we will take these people off your books, and you won't have to deal with them. We'll deal with them. And the way they dealt with them is to foreclose. And I think it's really it's a sad story, but I want to really thank Morgan Lewis, Greenberg Traurig, and Pioneer for working with us to bring this to the forefront in Massachusetts. And as Charlie mentioned, we were even starting on this before Tyler came down. We were using the bankruptcy courts, strong protections of debtors to really challenge this idea of it being a constructive fraudulent transfer, and that actually was something we were building on something that had been found to be valid in the Second Circuit and maybe some other circuits. So this was building on some strategies to really push this to the forefront and to help some very vulnerable people. I should say, in terms of our case selection, we were looking at people that were very sympathetic. And, in Worcester, our client, as we said before, as Charlie said, it was working to worked her entire life in a warehouse. and like really exceptional these days, did not serially refinance her house, was not, suckered into a predatory loan. She paid off that mortgage. And again, our Ms. Mills, single mom, struggling to pay her too. So these are house rich, cash poor folks, and we had basically a three-pronged strategy to move this forward. And the first one was a long-term legislative strategy. I have been working on this for 8 years, filing all sorts of legislation with sympathetic legislators, and there was incredible pushback because this was a system that was working, so to speak. It was basically a lot of municipalities had bought into this idea, especially with the high interest rates, with the tax foreclosures, with the municipality being able to recoup all the equity of the house and not give any to the homeowner, and also the debt buyer industry, that they were stepping into the shoes of the municipalities. And we would argue that it was clear that they were state actor for these purposes. And I'm glad that PLF is looking at that issue and pushing that issue forward. But it was working for them in a way in that they didn't have to deal with these people. And to be honest, I'll give you 1 second of defense of the municipalities, which is that some of these municipalities are very cash strapped. Springfield, Worcester, so they are trying to balance laying off firefighters, police officers, other things that that they feel like they need to keep in, teachers. And then they have sometimes people that owe $60,000 or $80,000 worth of taxes. So that's kind of the balancing here. But we, I think, for a long time knew this was really a terrible practice. So we started this legislative strategy, pushing, lots of pushback, and really had some great partners in the legislature that were really just championing this every single session. And if you're familiar with Massachusetts legislature at all, it takes almost a tsunami of events and pressure to get anything over the finish line. And that's what we were actually trying to do. We had a litigation strategy, which was to bring this to the forefront, that this was unconstitutional, that this was unfair, that this was predatory. And we were really, I again want to thank our litigation partners here, Pioneer, Morgan Lewis, and Greenberg Traurig, to push this really with some excellent briefing, where we got this incredibly good ruling from the Hennepin County Superior Court. This is unconstitutional, unequivocally. And that was bringing it to the edge. And then I should say, so we have a litigation strategy, we have a legislative strategy, and then what else is the missing ingredient? Good luck. So Tyler came down, and that really helped us get it over the finish line. So, with our and I should say, I'm sorry, I forgot to mention this, a media campaign. People talked about this, Andrew talked about this, and you're going to see, if you, in the follow-up email, you'll see a link to a clip from a local TV station. That TV station did maybe 4, maybe 5 stories in a row, incredibly, again, thinking about back to our case selection, these were extremely sympathetic people. So it's no wonder that they honestly made very good play in the media, because everybody, I've countless times people have come up to me on the street and said, how could this be happening in Massachusetts? This is so wrong. And it took the media campaign, getting some really sympathetic reporting and on TV, legislative strategy, litigation, and of course, good luck. I should mention, in terms of the legislation, we had great partners as well. The Boston Bar Association joined us in lobbying. The American Civil Liberties ACLU of Massachusetts was on board with us. Pioneer, of course, and the Massachusetts Association of Realtors. So when you have that kind of coalition lobbying and in the room with very sympathetic legislators, we were having meetings with people at all levels of the legislative process, and this is Massachusetts. Where'd it go? It went in the budget. So whatever works is the mantra here. But we did get it over the finish line, and incredibly, I should say, it not only does it fix the tax theft issue, the equity theft issue, because it requires very incredible standards for how you have to market this property, how the money has to go back to the person. And if they can't find the person, it goes to the state unclaimed property fund at the treasurer. So we've got, and that was not on the original bill. It was going to go back to the municipalities. It was going to go back to the debt buyers. So really thinking about what is the best way to get the equity back to the homeowner if the worst possible thing happens. But even more, the interest rate was reduced from 16 to 8%. That's still high, but that's half of what it was. And even better, it has provided the tools for municipalities to work with people. So now they can enter into a repayment plan that goes up to 10 years. It has a low amount that they have to put in a down payment to get into the plan. And the municipality can wipe out all of the interest. And they can set standards for who gets benefits from these. So it's likely going to be the people who I'm talking about, house rich and cash poor homeowners who are low income are going to be the most sympathetic. But if a municipality, for example, Springfield currently has a plan that's not great, but it does include small businesses and helps other people that homeowners and property owners in like example, an area that needs to stabilize, help them get current on their taxes. So, and stay out of tax foreclosure. So I would say that in my dreams, I would not have imagined we got this far, this fast, but thanks to our partners here and to a little bit of good luck, we got over the finish line.
Todd, you mentioned something that I want to be sure everyone understands the implications of, and that is that any excess equity, if they can't find the owner, which is sometimes the case, we've seen that, that it goes to the unclaimed funds pool in Massachusetts. Why is that important, and what are the implications of it?
Well, it's really important because the state treasurer has basically, this has been a place that exists. Maybe I assume it exists in many other jurisdictions. That is the total goal is to get the money back to the people. So they do lots of outreach. They do publicizing of lists. They work with people to document that you are the person that is entitled to the money. If you have to go through probate to get access to the money, whatever you have to do, they will work with you to ensure that you are getting that money if you're entitled to it. And again, just to think about the way the scheme was, and in fact, the original legislation had the money, the excess equity, if no one could be found, was going back to the debt buyer or to the municipality, which would have really kept this whole debt buyer industry going. And as we've seen in the past, it was extremely predatory and not willing to work with people. So it basically is as far as we feel it's the best way to ensure that the money goes back to the homeowner or their heirs.
And how does that happen, Todd? How is it that sometimes there's a piece of real estate, a home, an actual home, and they can't find anybody? What in your experience, what have you seen?
Yeah, so sometimes it's we saw a property that was actually recently we were trying to find the heir in one of the Western Massachusetts small communities. Sometimes somebody passes and it's their heirs don't think that they have any right to the property, or they think there's nothing to be done, or they say, oh, it's going to tax foreclosure, we can't do anything. So that's one thing where the heirs just give up. The other is that sometimes property is the person dies and they are not connected with the rest of their family. They're kind of cut off or not connected. And sometimes properties are essentially abandoned. And so it's unclear who has a right to that money. So this is, basically a safeguard so that if somebody can, wants to try to make a claim on that equity, that there's a very rigorous process for determining that they actually have a right to that. So it's a great system in a lot of ways.
Okay, I want to see if there are any questions. I have some more questions that I'd like to pose, but and we do have some in the chat perhaps, but let me ask this. This, and anyone in the panel can respond to this important question, and that is what's next. That's what we advertised this program, its history, and we've talked about some of what's next, particularly in Todd's portion, but the statute in Massachusetts has a 2-year look back period. I know that gave heartburn to some municipalities. That's what we've heard. So, but it expressly gave a 2-year look back period. But is there any basis for if someone lost their equity 3 years ago or 4 years ago? Is there any basis, for them to seek a restoration of that equity beyond the 2-year period? Anyone?
Well, I would say that there is pending litigation right now in federal court where people have lost their homes and they are making a federal 1983 deprivation of constitutional rights claim. That claim, actually, we made it early in one of the cases that we were involved in, and it provides, if you prevail, for attorney's fees and et cetera, and also damages. So those are alive and pending, and I think the 2 cases that I've looked at survived a motion to dismiss. And that look back period is longer than 2 years. And to the extent that Massachusetts was seeking to limit the look back period, I don't think it's going to be successful if somebody is participating in a 1983 action. And there's also some possibility that someone might file a class action in this area, especially if, for example, a community had a lot of tax foreclosures within that period. And then there are debt buyers. But I think the debt buyers are likely insolvent or would be rendered insolvent by these actions. So the unfortunate, I think it is unfortunate that municipalities that avail themselves of kind of aggressively foreclosing may be the most vulnerable today, and there is some concern about that the state may have to bail some of these municipalities out or get a fund together to help fund the settlements.
The other thing I think will be interesting going forward is how the statute is enforced. I mean, as Todd described it, there's two part. I view it as there's 2 remedial things they did to remedy the situation. The first is they made, by reducing the interest rate, by reducing the necessary down payment, by extending the payment period, they made it easier for homeowners to enter into payment plans. So that was the first. So hopefully there will be less cases that end up in foreclosure because you're able to get a payment plan. But they also provided in the statute doesn't prevent, municipalities can still foreclose on a home if there's a delinquent tax debt. They just have to return the equity afterwards. And the statute does that in two ways, either through a sale, and then once you sell it, you deduct, the amount and the costs, et cetera, and then you can return the equity, or through an appraisal process if the foreclosing entity deems it wants to keep the home. And, as a litigator, I'll be curious as to if there are cases that end up in foreclosure, will there be challenges as to the way the home is sold, as to whether the home was sold and whether the price received was a fair market price? Will there be dueling appraisals? Because it also provides, if I'm not mistaken, and Todd or Judge Bailey can correct me if I'm wrong, if there's a dispute as to what the value is, it provides for a cause of action to be taken in the Superior Court to dispute what you got back. So I'll be interested to see if there are disputes over that regarding, the equity returned and how that plays out.
Yeah, and I think it is a victory of sorts that it really talks about highest value, talked about really not just these were fire sales. In fact, the auctions are terrible. One was just held recently, and we probably would have taken it, as legal aid. I can reach out and solicit clients, and if I found somebody that was a good client in that particular case, I probably would have taken it, because it was definitely a fire sale. It was an auction, which the auction was completely unnecessary. But of course, that was before the statute was changed, and so that's the problem there. I do want to say that with these repayment plans, unfortunately, they left it as a local option, and we are trying to figure out how to reach and work with municipalities on helping them create these repayment plans that are good for homeowners. We want to see them wipe out all the interest. We want to see them do a 10-year repayment plan if that's necessary. There's even some ideas that you could, instead of making the down payment, you could make small payments until you get up to the down payment, and then you enter into the repayment plan. So there's lots of creative things that we could do. So if anyone on this call or this webinar is in a community in Massachusetts that wants to work with me on getting your community to do a really better repayment plan, I have a model ordinance that I can send you, and I'd be glad to reach out. My email is tkaplan@gbls.org, and I think that will be in the follow-up email as well.
Thanks, Todd. I want to be sure we get these questions out that were put in the chat. From Rachel asks the very reasonable question: can someone elaborate on how the Supreme Court decided on this issue before Massachusetts had a chance, or did? Isn't it usually the reverse, that a state Supreme Court would decide it and it would go up from there? So Tyler history, how did Tyler get to the Supreme Court before Massachusetts decided the issue? I can take a swing at that myself, actually. I think I will. So because we work on Tyler, I suspect that Jaimie could answer this as well. But the Tyler came from the federal system. Actually, it was, as I recall, I think it was the Eighth Circuit that had decided this adversely to her. And found that there was no taking, and that went up to the Supreme Court that way. As far as Massachusetts is concerned, there are state SJC decisions. One that comes to mind involves a private lien buyer called Tallage. Tallage is in the name of it. I think it's Lincoln Tallage versus someone, and it was a decision that our SJC made, but it didn't raise the question in that case, although it raised questions about Chapter 60 and its functioning. It didn't raise the question about constitutionality of Chapter 60, and the author of that opinion, who was Chief Justice Gantz, wrote a footnote where he said, well, Vermont has found this to be unlawful and gotten rid of it. New Hampshire has done the same. And what gives with Massachusetts, sort of, in my view, I've always said, inviting the cases that we ended up bringing in Rodriguez and in Mills, inviting that. So they weren't unaware at the SJC that this issue was out there. Anyone want to comment on that? If not, I'll
Well, Judge,
close them.
our experience in Rodriguez, the amount of pushback that we got was not really sustainable or practicable for a lot of these,
Fair
victims
enough.
of home equity theft. So I think that may have to do with something to do with as well, and when we lived with Andrew as well, it was tremendous amount of, and these, whether it's investors, typically investors have tremendous amounts of resource that a typical homeowner, and like Todd said, they're house rich, cash poor, simply can't afford the representation necessary to fight.
It's a great point, Charlie. So these are vulnerable people, they're people that receive notices sometimes in the mail. And, as a bankruptcy judge, I saw this with debtors, they would receive stuff in the mail. And if they know it's bad news. And what do people do with bad news? Sometimes they just throw it away. So, they're not getting noticed. Maybe they're ill, maybe they're whatever their problems are. They're certainly not up to fighting against a private lien buyer. So let me turn to this question, Todd. I think this is yours. Were the efforts to pass the amendments to Chapter 60 bipartisan, and what can we learn about the functioning of our state legislature, from that experience?
Well, bipartisan's a kind of little misnomer in Massachusetts, because we don't really, other than periodically having a Republican governor, we don't really have any balance of between the parties. But the way it does play out in Massachusetts is different legislators have different interests. You have suburban legislators, you have people that are in power, you have people that are representing communities that are really struggling. Springfield, Lowell, Worcester, lots of communities that are, Brockton, lots of communities that are having a very, very hard time financially and otherwise. So that balance is not prevalent, but I think that so to the extent that if you have something that makes it into the budget and it gets over the finish line, I think that you can see that it had broad support, especially also from leadership, because leadership has basically, if leadership doesn't want it to happen, it won't be in the budget or it won't be in a piece of legislation. So I think the key piece here is that leadership was sensing that they had to do something, and that it was going to happen. And luckily, the piece of legislation that got over the finish line really had so many improvements over a very short period of time. I would say over 3 or 4 weeks, we met continuously with legislators who were open to suggestions about how to improve the sale process if it went into actual sale after a foreclosure, and how to get those tax repayment plans in there, and all the things that we had been building on for all these years got really rolled into one piece of legislation, which is quite remarkable.
We're very close to, I have about 1 minute left, but I do want to ask Karen's question about the 2-year look back period and whether it can be told for good reasons, something like fraud, and maybe unconstitutionality would be a basis for tolling. I personally haven't researched that issue yet, but it's a very good question, and I'll ask if anyone wants to comment on it. Otherwise, I'll say we will send it on to our researchers, because it's an excellent question. And finally, Joyce asks, unfortunately, sadly, her family lost a $500,000 property some years ago, and she's wondering about joining a 1983 action. I don't think we're going to give advice on specific cases here today because it would be foolish for us to do that. But it's worth talking about whether there's a basis for bringing that action on Joyce's behalf.
I'm going to put you on the spot. Are you willing to field emails from people that want to, if they've been affected?
Yeah, by all means. And in fact, my name is on the Attorney General's website on equity theft. And I do get these calls. Todd gets these calls. I refer people who appear to be income eligible to him. He refers people that are not income eligible to me. And hopefully we get everybody represented in these situations. But that brings us to the end of the program. I want to thank everyone once again, and I want to invite Andrew Corrigan on from Pioneer. There he is. Okay. Hi, Andrew.
Hi, Frank. Thanks for this, and thanks to our panelists today, Jaimie, Todd, Charlie, Andrew. Frank, you as well. Just really incredible work that you all did, and an issue that I certainly wasn't aware of, but as soon as you talk to people about what this really means, they are just appalled to hear that the state let this go on for so long. So really, fantastic work there. I did want to give a little bit of an update to our listeners today that we have an incredible event coming up next week. It's the inaugural Denison Lecture happening on Thursday, October 17th at 6 o'clock. And we are having the former U.S. Solicitor General Paul Clement joining us, who will be giving a very timely topic on the issue of free speech on college campuses. His talk is entitled "Chaos on Campus: The Battle Over Free Speech." And given his experience at the U.S. Supreme Court level, we're really thrilled to be able to have him come in and kick off this important event. So if you're interested in learning more about that, please do reach out. Happy to share some more information. And then finally, on Thursday, November 7th, we will be having our 2024 annual dinner and Peters Lecture, which will be featuring Harvard economist Roland Fryer, who will be giving a talk on the importance of capitalism in terms of driving social mobility. So really exciting things coming up. Obviously, we'll be keeping a close eye on the Law Center and all the work that everybody's doing here, because the impact is really important and really tremendous. So thank you all for everyone. Thank you again to our panelists, and we hope that you have a great rest of your day.
Thanks, everybody.